Scott Baker.
Hey, Scott, it's Jessica Hartger.
Oh, hey, Miss Hartger. I was just looking for your phone number to give you a call, so...
So what's up?
Hello?
Oh, yeah, sorry. Can you hear me?
No, yeah, I can hear you loud and clear. Thank you. All right, so a couple things. I just got off another hearing, so I'm sorry for traveling around from here, but Elkins, we'll serve her with a attempt to compel her appearance at the trial. So I've got no problem doing that. I don't have any desire not to call witnesses or anything like that. So that's number one. Number two, I did reach out to the prosecutor on those warrant cases and asked them to agree to recall the warrants. And I have not yet heard back from them. So I will let you know as soon as I hear, and at some point during today's conversation we can talk about, what that looks like if they agree and what that looks like if they don't agree, and different possibilities, okay?
Okay.
The third thing was, I've been sending the links and things to everything, but we had some return mail from that Aetna address, which, like I say, it's something that was already duplicated by links, but if there was something where you wanted to give us an address, I don't know why it got returned from there, but I was just letting you know that it did.
Okay. Yeah, sometimes they get it mixed up between 498 and 489, and there's a condominium number with it. So that could be why. That's happened a couple times.
Okay, well, why don't you tell me what is the actual address, and I'll make sure we've got it right.
So it's 498 Aetna Street, and it's condominium number 102.
Okay. 498 Edna Street, condominium number 102. Okay.
And that's St. Paul, yeah.
I'll double check that and make sure, and like I said, I don't know if we'll have much occasion to actually physically send things, but since we got that return mail, I wanted to check on that. The other thing that I wanted to check on is there was a stipulation brought up with respect to our family wizard messages, that prior to the previous trial, Mr. Shea and the prosecutor, and I assume you were consulted about this, but I shouldn't assume anything, I guess, had agreed that they'd stipulate the foundation with respect to the our family wizard messages. In other words, that would, keep either party from objecting to the other party introducing those messages without having some foundational testimony from somebody with that company. That stipulation makes sense, and I understand why it was done, but I wasn't the attorney who did it, so I wanted to talk to you about that before I just said, yeah, we continue to agree with it. You know what I mean?
Right.
What are your thoughts? Do you have any, or do you feel strongly one way or the other, or where are you coming from on that at this point?
I mean, it's hard because I don't know what angle they're taking. I don't know if they're going from a contextual standpoint and they're looking at like the actual conversations that are had, because like at the end of the day, I still feel like even if those were admitted, like it doesn't really hurt me too much.
Well, I think, and here's what I can tell you. You look at the elements of the offense of stalking, and I think your case, and I'm not, force feeding this, so if you disagree, that's cool too, but it seems to me your case comes down to a couple things. Number one, whether everything that alleged really happened, and number two, even if it did, it doesn't establish the elements of what you're charged with, would be my argument. In other words, they have to prove that the 2 or more criminal acts within a 5-year period.
That I was trying to terrorize him, basically, that I had the intent of,
Terrorize.
yeah, exactly.
And to feel terrorized, the jury, I'm assuming, would get this instruction because it's kind of the standard instruction is to experience extreme fear due to violence or threat. That seems, and again, Jessica, I know, you and I haven't been seeing eye to eye on everything, and I regret that. And I'm trying to hopefully convince you that I'm on your side. I don't think they've got a good case for that, to be frank.
Well, especially considering we have a joint minor child, like there's 2 heavy-hitting key components. 1, we have a joint minor child. It's kind of hard to say that your kid's parent is stalking you during their parenting time.
Yeah.
You know what I mean? 2, I've tried to move out of the state, not only in the past, like since this started, I've tried to move out of the state twice to get away from him. And in the past 7 years, I have filed so much stuff in the courts in our family file to try and get away from him. I don't know if that's something that we can admit, like, into court, but I feel like those are really strong, like, combative, I don't know, stances, if you will.
When Judge Awesome had spoken about, history of the relationship and things like that, I think essentially what he was saying is, hey, if it's relevant to that element of causing someone to feel terrorized, then he's probably inclined to let it in. And he seemed pretty clear that is a two-way street. In other words, we know Cody's got all these allegations, but you also have a right to describe, the relationship. And I think it would be a tough argument for the state to say that isn't relevant to whether somebody feels terrorized or something, not only how they are saying they're treated by you, but also how you have been treated by that person. I mean, it's all part of kind of the whole picture of a relationship. So I think we will be able to, and it's probably going to be through you.
Well, even just their own experiences, though. I mean, if you think about it, I was arrested last year over Mother's Day, and in the report, they said that if I'm not arrested, that Cody and my son are going to be in imminent danger, but I was in a whole different state. Like, they arrested me, transported me, and then just released me again. Like, that doesn't make sense with a police report that says I'm a danger to the public. Like, you know what I mean? Like, it wouldn't even have to be my own testimony. Their own reports kind of work against them.
Let me ask this, because you have an absolute right to remain silent, and if you choose to remain silent in a jury trial, the judge and the prosecutor cannot even comment on that. So in other words, nobody can say, hey, look, she must be hiding something because she didn't testify, or try and draw some inference based on your lack of testimony or anything like that. If we choose to, we can ask for an instruction at the end of the trial and for the judge to tell the jury, hey, a defendant doesn't have any duty to testify, and you can't draw any inference from the fact that a defendant chooses to remain silent. You don't have to make that decision at this point. But
well, my goal is to get this to end before the trial even starts. That's my goal, is to destroy any foundation, because there hasn't been any, and like you said, they don't have a case, and they haven't. And I'm still waiting for a list of things that show that we should even be going to a trial.
And hey, if I had any way to avoid going to trial on your case, I would certainly agree with you. And I don't want to try your case. And if I do, I want to win it. You know what I mean? But if there was a way to get it dismissed ahead of time, I'd much prefer that too. I'm not against that. I just don't have a mechanism by which to do that.
So that's never happened before? Like, nobody's ever challenged, like, I can't, you know what I'm saying? Like, this has happened before. I know there's ways to do it.
So I've had cases that have been dismissed for lack of probable cause. But those come down to generally serious defects, in as much as what they're alleging doesn't constitute a crime, and that involves really no judgment as far as anything a finder of fact could disagree on. So in other words, if it's something that you're saying, hey, this is something that a jury shouldn't find, that's not something that we can get dismissed for lack of probable cause. If there's an argument saying this is something that a jury cannot possibly find, even if everything they're saying is true, that's the type of case that gets dismissed for lack of probable cause. And again, it's at this point we're set for trial, so I expect that to be the next step.
How am I supposed to expect that I'm even going to get a fair trial?
Well,
I should be able to trust that, right? I should be able to trust that the system is going to do what it needs to do, and that I'm going to get a fair trial. This has been going on for 2 years, and I have yet to be treated fairly. How do I even trust that?
I get the impression, and you may disagree, and so again, when I say these things, I'm not trying to be like, this is something that you have to agree with. I'm not trying to, bully you or anything, so I hope it doesn't come across that way. But I get the impression that Judge Awesome is interested in making sure that you're treated fairly. In fact, I want to discuss that a little bit with you more. I do know that Mr. Shea had made a motion to dismiss your case.
No, I made that motion.
Well, it looks like it was heard, and at the hearing, Mr. Shea appeared on your behalf, apparently. It was on February 7th of 2020?
Yeah.
Okay. So
that was 2 weeks before they smashed in my car window and arrested me and my husband.
Right. And that is something that there has been a ruling on that already.
And what was that ruling?
It was a contested omnibus hearing, and they found that there was probable cause to go forward with the charge.
Yeah, but I asked about it, and they never did anything. They never gave any data. They never gave any reasons. And when I started this jury trial last year, they were trying to withhold information from the jury, such as me being arrested 8 times.
Well, and that's not. Again, I'm not trying to go in circles with you, so I apologize if it seems that way.
No, that's okay. I want to know why they have probable cause, because people can make a complaint and they can say whatever they want, but if there's nothing to back it up, I'm trying to figure out where the probable cause comes in.
I can forward you. I'm not saying I even agree with any judge's orders on this case, but I can certainly forward you a copy of that order if you have not seen that. And that's where the judge that decided this, it was a Judge Edwards, sets forth her reasoning and rationale.
Okay, yeah, I would like that.
Okay, I'm going to make a note to myself so I don't forget. Let's go back to the stipulation with the Our Family Wizard. So essentially what that is saying is, the parties can object to messages from Our Family Wizard on other grounds, but it sounds like the stipulation was that both parties agreed that there did not have to be a foundational witness. In other words, somebody from whatever company deals with Our Family Wizard saying, yes, these are actual messages and this is the way our system works. So that's what we're dealing with. I don't have a strong feeling about that, but I certainly, again, didn't want to continue with that stipulation without talking to you first. In ways, it's, I believe there's probably some messages that we'd want in, so it's kind of benefits both, I guess, just as far as logistically, but I never feel compelled to stipulate to anything. As far as that goes either. I guess as a practical matter, it's not, I don't think it's harmful to your case or to us. It's probably something that the state has more means of getting a foundational witness in than we do, so it might even benefit us. But like I say, I don't feel super strongly about that. If you felt strongly that that's something that, after having, what's it been, almost 10 months to think about, that you wish you hadn't done.
I think the only thing, I guess, is that, like, to have an expert to testify to the validity, I think is important, only because I don't want a curveball to be thrown, and the moment we start introducing that type of evidence, then the state challenges its validity, and then it goes out the window. Like, I'm trying to avoid any curveballs because they're just out for blood, and I'm trying to avoid that. I really don't care either way, but that, it would help just to have those messages, but I don't care.
It's not going to be an expert as far as, it would be more of a records custodian.
Or a representative, yeah, whatever the case may be. It's technically expert testimony at that point, but...
No, not exactly. It's not something that requires any particular specialized training. They're not going to have their computer programmers there or anything. They're just...
Oh, sure, I see.
I don't know, is that an issue as far as, our family wizard? I think there's always an argument saying, well, somebody could have got somebody's password and put something in or something like that. But do you see that as, I understand your concern about them, trying to go against our evidence, but do you have concerns, particularly along those lines as far as, hey, some of these are bogus or stuff like that? Or tell me more about that.
No, I think the messages are true. I think that when messages are attached with some of the police reports that Kelly Coughlin made, I think that they're taken way out of context, and I think that a lot of her personal feelings are put into it, which is really unfortunate. But I do think it would help to see the full picture.
In that case, we're talking more about, what messages are introduced, and I think the stipulation probably still makes sense at that point.
Yeah.
So in other words, your concern is that they don't cherry pick and just, I guess I'll use a dumb example, or maybe it's not dumb, but, it's like looking through like a crowd of people and just picking out your friends. In other words,
yeah,
you don't
picking out what fits their narrative. Yeah.
Cherry pick, things and take it out of context, and the stipulation won't prevent us from preventing them from doing that. Okay?
Okay.
All right. Back to another question, and I don't know what discussions you had with Mr. Shea as far as the type of trial, and again, this is something that I don't particularly have any desire about, but...
Honestly, Scott, Kevin never talked to me. Like, I have talked to you more times than I talked to Kevin in 2 years.
Well, I'm glad, well, I'm not glad about that, but I'm glad that we're talking at least, and I appreciate you working with me. What I will tell you is, I know you had some concerns about the jury, and I'm not proposing this by any means. My general default is to have a jury trial, but also observing the hearing and observing Judge Awesome and a couple of the comments that Judge Awesome had made, I just wanted to bring up the possibility, if you wanted to, that if you chose to, you could have Judge Awesome be the trier of fact in this case.
Trial by a judge?
Yeah. Again, I'm not endorsing that. I'm not even suggesting it, but you had some concerns. I didn't know if anybody had ever talked to you about it. My impression from Judge Awesome, because he had asked, about if I had talked to Ms. Munnins or something like that, I get the idea that he thinks that perhaps this thing's a little bit overblown, but I don't know that. That's just...
No, I agree.
I'm trying to read vibes.
I totally agree. The vibe that I've gotten from him, like, the very first time I met him is when I got extradited, and the first thing he did was apologize to me, like, in a courtroom. Like, I don't think that he's a bad guy. I don't think that he's a bad judge. But I do think that, I don't know. I think I'll have to think on that, because I do think I have better odds with a jury, because they have to unanimously decide, whereas, my odds are better. That's 12 people that have to decide versus one. You know what I mean?
That's the whole rap against a a court trial is. A judge just has to agree with himself, whereas a jury, you got to have 12 people to agree. So I'm not going to ask you to make that decision today. I think that if you decided to do that, say on Monday the 28th, that we could get that accomplished. They could excuse a jury, but you don't have to decide that until then. And we've got some time to talk about that if you had further questions about that. I'm not really planning on bringing it up with you unless you bring it up to me as far as something that you want to discuss and investigate, or at least sound out doing further, because again, there's ups and downs to everything, but it's just something I wanted to make sure you knew that it's possible. So that's your call completely. That's only something that we can. All I can do is tell you what I think, but there's a few things that are exclusively up to you. How to plead, whether or not to testify, what type of trial to have as far as court or jury. Those are core decisions that are inviolably yours, not mine. And I'm always willing to talk to you about those, but I respect your decisions on that, okay?
Thank you.
All right.
Yeah, I'll probably take the weekend and sit on that and think about that.
And you can sit on it for a couple weekends because, again, trial's not till the 28th, so that's not a decision that you have to make really until the day of, technically. I think I've had it happen once in my career where a judge said, I'm not going to allow a court trial, which was very odd, and I'm not sure if that was even legal. I doubt Judge Awesome would deny us the right to have a court trial if you chose that. And I don't think the jury, I don't know if the state would be real wild about it. I get the impression they're not super thrilled with Judge Awesome, but I don't know. I don't think they have any basis to object to that. I think that's your right if you chose it. Again, we'll talk about that if you want to later on. Nothing you need to do now. Fair?
Fair.
Okay. All right. So, do you mind if I had just gotten off another hearing. I don't want to grab my notes, so you might hear me digging around.
That's okay.
And I want to talk about everything you want to talk about too. Okay.
Deal.
So bear with me just a sec.
You're good. Take your time.
You should look at my desk, Jessica.
I believe it. It's probably what my living room used to look like.
It was clean this morning, and gradually it went on and unclean, and now it's back to, yeah.
When I was doing a lot of my family files by myself and my appeals and everything, yeah, I can imagine, because my living room was covered.
Oh, sure. Yeah, the paperwork gets overwhelming. They talk about paperless, and ever since we've gone paperless, I've never seen so much doggone paper in my life. So. Let's see here. So just so you know what to expect, I've got a co-counsel here. Her name's Maisut Tao, that will be working with us on the trial. You saw her at the hearing. Maisut's an excellent attorney. She inherited a lot of Kevin Shea's cases. I thought yours on short notice would be one that would be better handled by two attorneys, and we had worked together a little bit previously, so, and maybe that's something you're not wild about now, I know, but I thought two attorneys would be better than one. Maisut and I have talked about kind of the division of labor, and I think I'm going to probably focus on jury selection and opening statements and presenting any of our witnesses. That would be you, Ms. Elkins, any of our evidence, and Ms. Tao is going to focus on cross-examining any of the state's witnesses and closing argument. So I just want to kind of give you a preview of the divide and conquer strategy, okay?
Okay.
All right. So I'm still looking through my stuff, but why don't you... Oh, here. Let's see. So we talked about Madison Elkins. We talked about the judge trial. We talked about history of the relationship. Okay, so I think you know from our discussion before that I've got my own philosophy on whether, there should be a ban on recordings or stuff like that in the courtroom, and that doesn't necessarily jive with Dakota County's philosophy, but also as an attorney, part of my job is to try and keep you out of trouble. So the judge did order, and I don't know if you have the ability to, I don't understand YouTube and all that stuff as much as young people, but he did order that you take down recordings. I'll let your conscience be your guide on that, but I'd recommend you do that if that's something that's within your control. And again, I don't necessarily understand YouTube and all of those things, but I made a note that he had said something about that. So I just don't want you to get, chastised or in any trouble or anything like that. It's the only reason I'm bringing it up.
Yeah, that's fair. I'm going to have to figure that out because I've never taken a video off YouTube.
Okay. Well, work on it or find a 12-year-old or something. I'm joking a little bit, but my kids tend to be a little bit better with technology than me. Yeah. Sounds like we're going to start with jurors on Monday afternoon was what I had written down. So that means that the morning will probably be just taken up with whatever arguments and motions that we talk about. I expect that there might actually be some free time in the morning, and then the jurors will begin selecting them in the afternoon. I suspect, although I don't know, that would mean we'll probably open the case on either late Monday or Tuesday morning. The state will begin presenting their evidence and witnesses. I'd expect that to take the entire day Tuesday, but I'm not 100% sure. And then I'd expect that we'd present our case on Wednesday and close the case on Wednesday. I would expect that Thursday would be the latest. Now, trials are uncertain things, and there's always best laid plans, and I've had, oftentimes it's a judge who delays things because they get called away to some emergency hearing, or, something weird happens with a juror, and they, we're waiting around for a couple hours till we know what's going on with them. Or, well, you saw in your case something weird happening with a juror with the whole COVID deal. So I can't guarantee you that it'll be done by Thursday, but that would be my expectation for a jury trial. Just for your planning and that type of stuff.
Okay, so obviously, like, if I come in for the first day and these 8 warrants aren't taken care of, they're going to detain me.
Well, so again, I have not heard back from the prosecutor.
Elliot will refuse. Elliot has been tormenting me for 7 years. Anytime I ever was on probation or anything, Elliot Kanish was on the case. He will not drop them.
If he doesn't drop them, then, if you appear on Monday for the first time to address those, I will ask Judge Awesome to, and he's saying he's not assigned to those cases, but I'll ask him to add those cases to the calendar and to have you arraigned on them and to release you.
Like, I'll do a book and release. Yeah, I don't have a problem with that. I mean,
I
I do want to know what they're for, because I still don't even know what the complaints say or who signed the warrants or anything like that. I still don't even know what I violated or who I talked to or what I did. So I would like that first.
Let me check on something. I think, with the case file number, I can't access, like, private information or get discovery on it because we haven't been appointed, but I think there's a public website where with the case file number.
Yeah, but you can only get the case detail. You can't see the full, like, you can't see the complaint. You can't see who signed what warrant, like.
What site are you using?
What is there? Mincis and.
So Mincis there's something new. Hang on a second. I'm gonna look and see if I can find it here. Bear with me.
Yeah, you're good.
I'm going to see if this works, and I'm going to send you a link, okay?
Okay.
Bear with me. I don't use this because there's another one. For cases we're appointed on, we have something called MGA, which is Minnesota Government Access, which there's rules we have to follow and stuff like that. So we have a different mechanism to use, but there is a public one, which I think should give you, like, complaint and stuff like that. Hang on just a second. I'm going to type in one of these deals and see what... Do you have all of those court file numbers, Jessica?
I do actually.
Okay. I'm going to send you a website. I think this will work for you. I don't think it's just on my computer. Okay?
Mm-hmm.
Bear with me just a second here.
I mean, I did send a informed consent and a data request to Jeff Long and to Burnsville to Tanya Schwartz. So hopefully they get that to me, but I'm not going to hold my breath.
Well, this'll at least get you, like, the complaint and stuff. Hang on just a second. I'm going to email you this right now.
Yeah, I don't know. Like, I feel like I'm the only one that thinks that, like, somebody getting 8 warrants in 24 hours is a little extensive.
It seems vindictive, right?
A little bit. Like, I don't know why, like, I feel like I'm the only one that sees that.
Remind me what your, oh, no, I found it. Royal White Rabbit Hunter. Yeah.
Oh, yeah, I just sent you an email, too.
Oh, okay.
And then I CC'd Miss Tao.
Okay, cool. So I just sent you an email with that. You can play around with that, but I think if you've got those file numbers, hey, you should at least be able to see, like, the probable cause statements and the complaints and stuff like that, okay?
Okay, cool.
So, sorry for jumping around a little bit here.
No,
but,
that's okay.
We had kind of touched on the subject and then veered off it, but and you don't have to decide until the state has presented their case and rested, but do you have any inkling as far as your decision to testify or not? Is it an absolute yes or an absolute no, or a wait and see type of thing? And there's no right answer. It's whatever you think. So I'm not suggesting anything one way or the other. I'm just curious.
Well, I definitely like to weigh my options because I've seen cases where people testify on their own behalf and it gets them in prison for 20 years, and then I've seen people testify on their behalf and they walk with their freedom. That's something I definitely want to also think about. I don't want to just make any, jump the gun rash decisions.
The reason I'm asking is if there's a possibility that you testify, and probably we won't do that today, but maybe we'll set up something to talk next week, a couple-hour time frame. What I like to do is at least once and sometimes several times, I talk to my client about what their testimony will be. Usually I put together a little Word document, and then I move things around and organize it, and then I will go over it a few times minimum, just so if you do choose to testify, we're able to do so in a professional and effective manner. some of my clients say, well, I'm telling the truth, I don't need to practice. It's got nothing to do with that. It's, and I've testified in court, it's a little bit nerve-wracking. It's a situation where I think it's important to be on the same page as the person who's going to be asking you direct examination questions, to be frank. And trust me, I'm not trying to create more work for you or me, but I think it's really important. What I like to do with my direct examination is start out with my client telling me about them and their life a little bit. No, we don't have to go through every detail or anything like that, but, where they grew up, where they went to school. Sometimes my clients will talk about their school activities, what they've done for work, their families, things like that. I think that accomplishes a couple purposes. Number one, it humanizes you to a jury, and number two, it allows the jury to see what the truth looks like, because they know you're not lying about, growing up in this town or going to this elementary. And I think that's important for a jury to, have that and not just jump right into, well, this is what I did and this is what he did and so forth and so on. We get through that too, but I like to take a pretty deliberate and structured approach towards my clients testifying. I've had plenty of clients that I've worked with on their testimony that, once we get through the case, we feel like we've got a good shot, and they choose not to testify, and I don't consider that wasted work at all. It's actually helpful to me in the process to know what happened, and designing a direct examination is a way to get very detailed into that, and it also helps me learn more about my client, and my client get used to working with me. So if that's something, before we're done today, we'll set up maybe a time next week to start that process.
Yeah, I would definitely be interested. I mean, obviously, being in a courtroom setting isn't something new for me, so it's not like a nerve-wracking thing for me. I don't mind personally, and
well, you're a pretty articulate person, and you don't seem to lack for confidence. I mean, you're not socially awkward or anything like that. So I think that will serve us well to begin with. But even with all that, I think it's important to at least have you and I on the same page before we just go in there. And I guess the last thing I want to do is wing it, you know what I mean?
Right, yeah, agreed.
Yeah, so...
Which I kind of feel like that's what's been going on, like, this whole time. It's just been, like, at the seat of your pants, Yeah,
let's make sure we're ending that now, then. Tell me, so I've touched on a number of things, and we'll send out that probable cause order. I just sent you the document access thing, so play around with that and see what you can get. I think I'll give you some stuff. Other than Ms. Elkins, is there anybody that you think we need to be looking at as a witness? I know that was like the one possibility previously, but like I say, 10 months have gone by, and we're different attorneys, so if there's other witnesses, I want to know about them now, and there doesn't have to be, but like I say, I'm trying to cover all my bases here.
Sure. Let me get back to you tomorrow morning about that, because I just want to look through my case files one more time and just see if there's any other witnesses that would be beneficial.
Yeah. Just whenever you do know. It doesn't have to be like right away tomorrow morning, but I certainly don't want to be in a situation where, I've had, unfortunately, deals where, my client showed up on the day of trial and said, well, I want this person as a witness, and it's the first time I've heard of it, and then, bad things happen, which is either, number one, judge says, well, I'm not letting you call that person because you didn't disclose it, or number two, and I will put Ms. Elkins' statement in disclose that to the state. I think they've got it, and I'll also make sure she's on a witness list, so we won't run into that with her. I think with our hearing, they've got pretty adequate notice anyway, but we'll do the formalities. But and I sure as hell don't want the thing to get continued, is the other worry. So that's why I want to make sure we're on top of that stuff.
Okay.
Tell me what questions you have or topics that you have that we haven't talked about that you want to talk about. And again, before we go, remind me to figure out a time that's good for you to talk next week, okay?
Okay. Well, the one thing would be my recent correspondences regarding the missing data that we still don't have.
So tell me, just a second here. Okay, I just saw your email that I got at 4:18 here. I'll look through that.
Oh, perfect. Yep, that would be the second one. So that one, and then the one I sent you, like 2 days ago, I think it was?
Sure.
And those should be pretty detailed. But like I said, I also just did a data request too. But if there's anything you two can do on your end to help expedite getting that discovery, because like you said, we're only a couple weeks before trial, and there's still a lot of imperative data that we need to gather.
All right.
Are you still there?
Yes.
Oh, okay,
yeah,
cool.
Absolutely. So I've got like an email, and then it's got like blocks that say Hartger Lakeville release IC PDF.
Oh yeah, those are just those are copies of the informed consents that I sent, and then copies of the data requests that I sent to both Jeff Long, to Lakeville PD and Burnsville PD.
Okay. I'm not 100% sure I can open all those, but I've got the...
Oh yeah, you don't have to open those. They're just like for your record,
Okay.
so you have them just in case.
Text is by my Jeff Long, Lakeville Police, and Tanya Schwartz, Burnsville Police Chief.
Yep.
The starting there. Okay. Well, I guess... Bear with me just a second.
You're good.
It looks to me like what's there is a transcript of Mr. Shea at a hearing, and then a link to a YouTube video, and in reference to the case number, I think this is probably the hearing that was at, November 5th,
Yep.
2020. Okay. So
November,
tell me what,
5th or 6th, yeah.
Yeah. So tell me what, and I apologize if I'm seeming dense here. It's not my intent to be obtuse, but tell me what you're asking for there.
Let's see, which one? This one is going to Lakeville?
It's Tuesday at 1:21 is when I got you forwarded it to me, I think.
Okay.
Jeff Long and Tanya Schwartz. So
Yeah, so I'm looking for any and all of my comprehensive law enforcement data. So any and all communications and basically any communications that are connected to this file number or to my name, I want all communications. I want all data, everything.
okay.
And it's kind of, if you open up the other one, this is just the informed consent. If you open up the one that's page like 1 and 2 that has all the warrants and everything listed on it, that's a little more specific for the data that I'm requesting, just in that regard, which I've already certified mailed and emailed to them as well. So I'm just waiting for them to get back to, well, I guess either me or you, but when you say that, are you referring to
the one that's just to Police Chief Long?
No, so there's not one that's just to Police Chief Long. It's to Police Chief Long and to Tanya.
Okay, I've got that one, but I also had one that you forwarded to me on Friday.
That was a
I
complaint.
think that was, okay.
That was a complaint for parental deprivation.
Okay. So, and then I'll look at the one you just sent me.
Yeah, if you read the permission to release, I did CC you on that one. If you read the permission to release, it actually lays it out pretty specifically, like, especially for Lakeville PD, the exact data that I'm looking for. I think it's like 4 points, something like that. 1, 2, 3, 4.
Tell me, here's something that's come up. Tell me about the cell phone, because, from what I gather, and again, we've talked about this a few times, so if I'm missummarizing it, let me know, but you'd had a conversation with one of the police officers.
Oh, you're talking about the ping data?
Say, hey, ping my phone. They said, yeah, I'll do that, and they never did. And so I guess here's what I can tell you that, officers, it's kind of crappy, but they can tell you that they're going to do something and not do it, obviously. They did that.
Right,
but,
more than once.
And there's not much we can do with that, but
I just want to know if they did or did not, I guess is kind of what I'm going for. I want to know if they took the step to do it, because there's nothing else that proves that I'm there. And in that same complaint where Josh Flynn quoted everything, he also stated that not only would he look at my ping data, but that my voice was heard in the 911 dispatch call. And those are the only two things that put me there, because there's no other eyewitnesses, there's no nothing. It's all hearsay at that point. So that's why this ping data is very important to me, because lo and behold, my voice is not in the 911 recording, so the only thing that would put me there then would be that ping data. So I want to know if they did it, because naturally, why wouldn't they do that to prove their case? Like, that's a done deal. Like, that's a slam dunk. So if they didn't do it, there's a reason why they didn't do it, and I feel like that's something substantial that the judge should probably know about. You see what I'm saying?
Well, we can certainly make that argument, and you can anticipate what their response would be, of course, but
I just want to know if they did or didn't do it, and I don't know how we go about finding that out, but I'm sure you can figure out a way.
Well, I guess ultimately, if there's evidence that the prosecutor hasn't disclosed, that's a problem too.
Right, and that's my main problem.
Follow up with the prosecutors. I don't know as we'll have the ability to access that data.
Well, the problem is that there hasn't been any data presented to me yet that supports the initial complaint. And that's what I've been waiting for. I've been waiting for either like a phone ping data, an eyewitness, a picture of a bite mark, my voice in a 911 call. You know what I mean? I'm waiting for at least 4 key elements to their initial complaint, and there's nothing that supports it.
I totally hear what you're saying. And again, I'll send you a copy of that order. But I just wanted to make sure I understood what you were looking for.
No, you're good. That's what I'm saying. That's the data I'm looking for. That's the data I'm still looking for 2 years later, and that should have already been given to me.
Okay.
So somebody's either withholding it or it doesn't exist.
Okay. I will. I'll follow up with you on that and find out what I can, and keep you updated. And I'll look through those emails real thoroughly, okay?
I appreciate that. That'd be awesome. I tried to be very thorough and specific with them. I tried to not keep them long-winded.
No, they're divided into numbers and things, so it's well organized. Yeah, I appreciate that. Let me ask you this: have you had any subsequent contact with Ms. Elkins? And the reason I'm asking is to put a subpoena on her. I'm assuming she's at the same place, but
I haven't talked to her since I got arrested last year.
Okay, fair enough. All right.
Because Lakeville PD contacted her, and she ended up telling them where I was in Michigan, and it was a big whole ordeal, but that's why I haven't talked to her or my mom, because if it wasn't for them, I wouldn't have got extradited over Mother's Day. So her and I haven't spoken since, and I have proof that I want to send to you of a conversation that her and I had about Lakeville contacting her right before that happened.
Okay.
which is weird. I don't know why law enforcement is contacting my witnesses, but I feel like there's some rule against that, but I don't know.
Well, yeah. If you want to send me something, I'll certainly review that too.
Yeah, that would be awesome, because law enforcement contacted my family, my husband, like my friends. Like, Lakeville was contacting everybody in my life. And I don't know what was said to them. Nobody will tell me what was said to them. But I have a feeling by everybody's actions after those conversations, it probably wasn't anything good.
Yeah. And I understand.
It is what it is.
Okay. I understand. Well, I've got some things on my to-do list. What, anything else that you want to talk about now? And I got all the time in the world, so if there is, that's fine. If not, I definitely want to set up a time to talk next week and set aside at least this much time to kind of start crafting a direct statement. And if we end up doing that later in the week, I'll follow up with you earlier on the other things, okay?
Okay. Yeah, no, I think the only thing that I really just want to get handled would be the primary email that I just recently sent you today, regarding the communications and, any statements, things like that, because I think those might take a little bit longer to get, so I want to try and get those as soon as possible and, go through them, because I have a feeling it's going to be quite a bit.
Okay. All right. That makes sense. I'll do everything I can on that. Hey, just so you know, I think you'll probably be getting a call from Mr. Holmgren. He had gotten forwarded your complaint, and
Who's that?
That's the chief public defender here, and I told him that I was going to be talking to you this afternoon. But even so, I think he'll probably be calling you to follow up, and you can tell him whatever you want. Don't hold anything back. I've got no problem with that. Okay.
Fair.
Okay. All right. Any other questions or anything?
What time next week do you want to...
Thank you for reminding me. Yeah. I'm going to pull up my calendar here.
Let me pull up mine. Hold on.
Yeah. What's your work schedule like? Are mornings or afternoons generally better, or is it a regular schedule, or what's best?
Typically, we'll see, we're on an hour time difference, so you're an hour ahead of me.
In Mountain Time, right?
Yep.
Okay.
So, mid-afternoon typically works well. I try to work as often as I can, so I pick up shifts, and I'm just a mad woman out here right now. So, I can definitely work around whatever schedule you have.
Well, if you got it, I can work around your work schedule too. So what time do you get off on Monday?
So let me look. Monday the 14th. I have that day off.
Oh, do you?
Yep.
Okay. You want to just set something up for then, and we can at least get started, and then we can plan more later that week. But
sure.
Sooner rather than later is always best.
Yeah. What time?
I'm pretty free, knock on wood, and so whatever's convenient for you. If you want to do it, if 3 my time would be 2 your time. Is that right?
Yeah, let's do it.
Does that make sense?
Yep.
Okay. I'm going to put you in for 3 o'clock. I'm going to put your phone number right on my meeting appointment here, so I don't have to go look for that.
Scott, can I ask you a question?
Of course.
So, tomorrow's my son's birthday. If I were to I don't know, call like my son's grandmother or something, just to see if like, I don't know, if they'll answer, or if they'll even let me talk to him. Could that be considered like a violation?
I think it could. I'd be cautious about that.
Well, because that's the only reason I haven't talked to him or seen him in like 2 years. And like this is his second birthday that I don't get to like see or talk to him, and like I can't send him gifts because that's a violation. Like I can't do anything because everything's just a violation. And like my kid has nothing to do with it, and like I just don't know what to do.
Yeah, it's a shitty deal. Let me see what the conditions are.
I think the only condition that even remotely close like relates to my son is that I can't go to his elementary school, which by the way I find that to be very strange, but I just like wanted to ask because I don't want to like try and then have it bite me in the butt and then have me not even be able to, you know, talk to him or whatever.
Yeah. So I'm just gonna read through these conditions on the felony case here. It's non-interventive residents of 1 mile radius, sign all releases of information, shall release psychological evaluation to stay within 14 days, conditions other, comply with all existing protective orders. So I don't know what's all in your family law case currently.
There's not one between my son and I. There never has been. It's anytime there was an OFP, it was always against Cody. Like I've never not been able to talk to my son, and that's what frustrated me because this criminal, apparently I'm innocent until proven guilty, but in my family file, they're treating me as like I'm a convicted felon getting ready to go to prison for 20 years, and they won't let me see or talk to my kid, which I know is unlawful. I know it for a fact, but like I just wanted to make sure because I've never had an OFP with Colton and I've never had anybody tell me I can't talk to him or see him. And that's why this is so messed up, because my kid's dad like perfected it to where I literally couldn't be a parent. Like it's the most like obvious parental deprivation ever. And I just wanted to know if like if that's considered third party or anything, but like I just don't want to get in trouble.
I can't speak to what in detail is in that family law case. So if it's not in violation of that, that would be the risk, is some sort of accusation that
that I'm stalking my ex because I'm trying to call my son on his birthday.
Well, and again, it's...
Oh, that's what he would say. He'd say, she's stalking me again. All the way from Colorado.
I'd say that, along with, I don't know the likelihood that they'd even allow you that contact at this stage, probably weighs against even making the attempt. I share your concern about being accused of things, even if you're not technically in violation of anything. So that's my advice.
So it's best to just suck it up and not even try?
I think that's probably the safest. There won't be any potential of somebody saying that you were passing along messages or, you know, making any oblique references to Cody or the case or anything like that. So that's the safest path. That's my advice.
Okay.
And I'm sorry, I don't take any pleasure in that. I can't even imagine your pain. I get it.
That's okay. I asked you because I wanted the truth.
Okay. Well, I appreciate that. All right. Well, we're set up to talk on Monday at 3 my time, 2 your time, right?
Yep.
Okay. Well, I will call you if you don't call me, and we'll keep moving forward, okay?
Okay, sounds good.
All right. Thank you, Jessica.
Thanks,
Take care. And if something comes up tomorrow or before then, just call. If I don't answer, leave a message.
Sounds good, I will.
Okay. Thank you.
Have a good
Bye.
one. Bye.